Okay, we're streaming. Tasha, thank you. This is a matter of Fifth Third versus Med Service and Askins. Ms. Melissa Langers for the plaintiff, Mr. Thompson for the defendant. And this is the plaintiff's motion for summary disposition. Mr. Thompson, did you file a response?
Judge, I did not. I have to provide an oral explanation for that, and I'm certainly prepared to do that, but I did not.
All right. I just wanted to make sure that it didn't get in and somehow not make it upstairs, so thank you. Go ahead, Ms. Langers. I did read your motion in brief.
Yes, good afternoon, Your Honor. Melissa Langers on behalf of the plaintiff. As Your Honor already pointed out, the defendant has response to our motion for summary. I have had many conversations with opposing counsel. I understand the defense position, but unfortunately, he has not provided any counter documentation or evidence to support his claims and his defenses. So we are seeking a judgment today, and I did attach a proposed order to my motion packet. The total judgment amount would be $52,957.43.
So I noticed that your brief said there was a affidavit attached, but I couldn't find an affidavit. What I did find when I went looking for it is that Mr. Brent Askins did file a counter affidavit. Looks like, I can't tell, in February.
That's correct.
So I do have an affidavit from him, but I don't see one from the plaintiff.
Ours is attached.
Did I look somewhere else for that?
Complaint, Your Honor.
To the complaint. Okay.
Yes.
Hold on.
Sorry about that. Yes.
Let me find that. I mean, is it? Okay, I see it now. Pardon me. All right. Pretty straightforward. And then let me look at Mr. Askins' affidavit again.
That was for good cause, Judge, with respect to the fault that had entered. There's an affidavit of meritorious defense, good cause.
Okay. So it appears that Mr. Askins' affidavit is based upon an allegation that the personal guarantee was previously released. Is there anything in writing showing that a guarantee was released?
That's exactly what I needed to address, Judge. Discovery was directed in that regard, and it's very clear that there was a consideration made by the bank. Here's where the problem arises. Mr. Askins, upon the receipt of the documentation from Ms. Lenger's office, actually went back to the bank and spoke with several individuals that were there, still employed with the bank and were employed during the period of time where this personal guarantee was released. And there's a current employee, and I've emailed this to Ms. Lenger's, that is willing to testify, or indicated preliminarily, I should say, he would testify preliminarily that he knows that Mike Jors, who was formerly employed with the bank as a commercial loan officer, would talk loud in the lobby, talk loud. She recalled him talking to Mr. Askins and said, yes, the personal guarantee is released. Now, the problem with this, Judge, is she's still employed with Fifth Third Bank and is not willing to sign an affidavit or to testify to put herself as an at-will employee, that she could lose her job. I've had conversations with this employee as late as 3 o'clock this Saturday afternoon. Communication has been difficult because this employee's husband has been hospitalized with some health issues. I was gone for several days, and communication obviously has been difficult in that regard. So that's a long answer to your question. There is nothing other than we have this employee who's between a rock and a hard place, as is Mr. Askins between a rock and a hard place, because this employee says, yep, I remember the discussion that it was released and that Mr. George told you that. This employee will say that Mr. George, who is no longer employed by the bank, would make all kinds of statements to people, and that they are continually cleaning up his problems. But we have nothing of substance. What I was going to suggest to the court, if I could have discussions with Ms. Lengers, as I said, my discussions went as late as Saturday, and I asked her to call me this morning, and I called her yesterday and today and haven't been able to get through to her. But if there is some way that we could make sure that this particular employee's employment is not adversely affected, I don't know how that would work, but the proposition would be that if she had a guarantee that her employment would not be adversely affected, she would sign an affidavit to what she told me is the truth. She has no relationship with Mr. Askins, knows him only from his relationship with the bank, and but obviously he's afraid to sign an affidavit. And the reason why all this is important, Judge, besides the obvious, is that Mr. Askin has been steadfast, adamant that he was told that that personal guarantee was released. And what happened was this note would renew on an annual basis. Mr. George would call him into the office, and Mr. George would say, everything is fine. You just sign there. You don't need to read it. Everything's the same. Mr. Askins would say, has a personal guarantee been released? Yep, it's not in there. Don't worry about it. And that's kind of the rock and the hard place that we're between.
So I'm struggling with this. The fact that Mr. George was a loan officer?
That's correct, Judge. And a manager.
I'm struggling with whether a loan officer's oral statement, don't worry about the guarantee, or the guarantee's been released, is that effective to release a guarantee?
Well, we have a detrimental reliance argument in that regard, Judge. That's where the situation. He certainly has apparent or implied authority as a manager and a loan officer to make that statement, upon which reliance should be placed. No question about that.
What's the reliance? That's what I'm trying to get at. I was under the impression the obligation already existed.
The reliance is that the personal guarantee had been released, and that the threat was made to move these accounts for this business to another bank unless the personal guarantees were released. And he was told, don't move the accounts, the personal guarantees have been released. What it was, Judge, was a blanket guarantee that was signed initially. And so if somebody with implied or apparent authority indicates that the guarantee's been released, Mr. Askins relied upon that.
So I want to make sure I understand. You're asking for an opportunity to speak to Ms. Lengers right now. Did you want me to put her in a?
I mean, I can do that, Judge. I don't know if she'd have the authority, but I certainly would relish the opportunity. I told Ms. Lengers last week in a email that I don't like to practice this way. We've been chasing this employee, and I do apologize to her as well, and to the court. The court knows me better than Ms. Lengers does, but this has been something that has been very important, and Mr. Askins and I have been on this with this employee, for the last 3 weeks.
Got a lot of plate.
But she's got a lot on her plate too, with a very sick husband, apparently.
I don't want to put her in a bad situation.
And as Brent just said, I mean, who do you slay? Do you save one baby? Did you slay the other baby? And certainly she could lose her job. Or, how do we resolve this? So I'm happy to talk to Melissa right now. And I would have called her earlier today. I had 2 funerals this morning, Judge. I'm sure you're aware of the 2 funerals in town that were fairly prominent that I attended. And I've been out all day until 1:30 today.
So, Ms. Lingers, I mean, is there anything that could be resolved by you speaking briefly to Mr. Thompson?
Your Honor, I'm happy to just give my little 2 cents in position here with his argument and the situation. I completely appreciate the efforts they're putting into this supposed employee and the situation. However, the contract's clear, like that guarantee, and it's in my motion, it stays in full force and effect until it's expressly terminated in writing. It's right there, black and white. So I'm, and plus I've already sent to opposing counsel in our discovery responses, the little documentation I did have of the bank notes where Mr. Askins did, we acknowledge he did request the release multiple times. However, every time the bank denied it and stated it would be kept in place. And that all that documentation was provided to the defendant. So again, and I don't even know what the testimony, how that would change anything when the contract's clear that it has to be in writing to terminate and release that personal guarantee. And he has not set forth, or brought forth any type of writing. So, that's my position. Again, I'm always happy to talk to opposing counsel. We've worked on other matters before. He's great. So I'm happy to talk to him, but my hands are kind of tied. The bank's really going to have the same position that unless there's something provided in writing, they're entitled to this judgment.
So, Mr. Thompson, I thought I heard you say that Mr. Jors no longer works for this bank.
He does not. And I've had several conversations.
Have you contacted him? Have you deposed him?
I have, Judge. And he denies, he doesn't specifically deny indicating that. He says, I don't recall anything of that nature. I don't recall. That's what he tells me. I actually know him very well. He works for County National Bank, Judge, and I represent. I mean, this is a small town. And I've talked to him numerous occasions about this. He'll say, yep, I remember there was a request ever made. I remember Dr. Askins, Brent's dad, said he wasn't going to give a personal guarantee. And ultimately, he did give a personal guarantee. And he was also told that his personal guarantee was released. And that was the only reason why, in reliance on that the account wasn't moved around or moved to a new commercial loan because of they were told that the guarantee had been released.
There were a number of other accounts that have been moved.
All right, I am going to give, I don't know that it's going to accomplish anything. I will create a breakout room. I've got some other folks waiting. I'll go ahead and call their case. And then when you're done talking, just come on back in. And then I will recall your case.
All right. Thank you, Judge.
Thank you.
Hope we don't want to leave meeting.
Okay, Pratt versus Employers Mutual.
Yes,
Counsel, state your appearances, please.
Paul Mullenbach on behalf of the plaintiff, Nina Pratt.
my name is Mike Ryan, Judge, represent EMC.
All right, and are you expecting anyone else to be present today?
I'm not.
I'm not either.
Okay, so I think what's in front of me today is the motion to substitute the trustee as a plaintiff. Is that correct?
That's one of them, yes, Your Honor. That would be my motion.
All right, let's address that one first. It would seem appropriate based on my understanding of what's happened. Apparently the bankruptcy estate has been reopened because of the timing. This is in fact a claim that belongs to the estate, so the proper party in interest to pursue it would be the bankruptcy trustee. Is there opposition to that motion?
Well, Your Honor, there is. I have my own motion for leave to amend my affirmative defenses and summary disposition motion. It's kind of all wrapped into one. My position on this is that the Pratt lacked standing initially to pursue this, and that for that reason, this request now is defective. I've also raised the judicial estoppel argument that I know you've reviewed. But in light of the bankruptcy trustee's order, Your Honor, that might all moot all of this. I've laid out my position pretty well in the various pleadings. I'll leave it to Your Honor's discretion relative, obviously, to what to do here.
I think the most expeditious way to do this is for me to grant the request, allow the trustee to be substituted in as the proper party. And to the extent you are seeking dismissal based upon wrong party and interest in judicial estoppel, I think those are made moot by me allowing the trustee to substitute. I mean, otherwise, as I understand, even if I granted the motion as to the current plaintiff, there's still time for the trustee to reinitiate litigation. So I don't know that that helps anybody. So
I'll acknowledge the point, Judge. I think my judicial estoppel argument is what it is, but you know, it's Your Honor's docket. Your ruling is understood.
So as to the, there was a motion for reconsideration filed and a whole bunch of pictures that I didn't see the first go around. I think what I did is said, okay, I'll reconsider that, but I want Mr. Mullenbach to have a full opportunity to respond and address that. Where's all that at? I'm assuming I'm going to hear about that at a future date. And I'm also assuming, Mr. Mullenbach, that the trustee is going to hire you to continue representing this claim.
That's true, Your Honor. That's all in the works right now. And certainly that's not a problem for me. That probably should have been done that way to be in the beginning, but there's a lot to explain behind that. But I think that's moot now that you've granted the motion for leave to amend, and I'll do that. In terms of the motion for rehearing, I think Mr. Ryan has filed a motion for rehearing and provided pictures. I think I provided some pictures in response, as well as some arguments concerning whether or not Mr. Pratt was standing on the step on the back side of the truck, or the running board, or whatever you want to call it. I don't think that changes anything from where the court already ruled. I mean, it's clearly obvious that he could have been standing on that step or running board at the time he was struck by the pickup truck, just by the fact that the pickup truck's right front end hit the left rear end of the garbage truck, and he was thrown onto the hood of the vehicle, the hood of the pickup truck. So I still think that's a question.
Yeah, I'm not in a position to rule on that. I was just curious. I remembered that, and I remembered specifically seeing all these additional pictures. Why didn't I see those in the first go round?
I'm not sure. Maybe that question was for me or Mr. Ryan. I'm not sure, but I know that I thought I had sent pictures in my first response showing where.
There were some pictures, but wow, when I saw these, there was a whole lot more pictures with a lot more angles and so forth. So,
Your Honor, may I respond very briefly to Mr. Miller, what Mr.
Sure.
Miller just said? Okay. I guess, I suppose the question in the first instance is there any reasonable basis to conclude that this young man was standing on this running board when the incident occurred? And I would suggest to the court, if you look at those pictures, and Mr. Millenbach put one, the kind of the key one in his brief on page 6, if this young man was actually standing on that running board when this accident occurred, he would have been pinched at foot level. He would not have been hanging beneath the running board with his feet a couple of feet off the ground, as all of the witnesses post-accident have testified. And so for that reason alone, that simply does not support the conclusion, not speculative conclusion, that this person was standing on that side running board. But Your Honor, relative to the testimony, the story of this claim, I was quite careful when I took the depositions in this case. And I'm just going to run through this very briefly because I've cited this testimony at length in my pleadings. Wayne Goody, the witness who was in the vehicle approaching from the opposite direction, testifies that as he's coming up, he's going about 25 miles an hour. He sees this young man who is later he recognizes involved in the accident, peering around the side of the garbage truck, looking in an easterly direction to see if there's traffic coming the other way in Goody's direction. Tyler Street, his Pratt's co-worker, who was on the passenger side of the vehicle, testifies that as of the instance of the collision, Pratt had already emptied his trash can. His trash can was sitting on the street. He, Pratt, was standing between the can and the back of the garbage truck, about 2 feet away, and he can see his feet when this is transpiring. It's almost instantaneously after Goody goes by that the collision occurs. I take pains to point that evidence out, that testimony out to you, Your Honor, to establish that the only reasonable, non-speculative evidence that we have here by way of testimony is testimony from Goody and Pratt that the last time anybody sees him before the accident, Pratt is standing on the ground a couple of feet away from the rear of that garbage truck. And then in relative bang fashion, excuse the verbal machinations here in light of what happened, but in relative swift fashion after Goody goes by, this unfortunate accident occurs. And I would even go so far as to direct your attention to Sergeant Niles's testimony, who testified at page 25 that he thinks Pratt was standing on the ground when the accident occurred based on what he saw when he was there. So for all of those reasons, Your Honor.
And I hear you. It's not in front of me today, so I'm not in a position to rule on that aspect of it. But I can tell you, I remember clearly my hesitation at granting summary based on the information that was in front of me when you argued the motion was that there was testimony he ended up on the hood of the pickup truck. And I was having trouble with the possibility that he looked up, saw this truck coming and tried to get out of the way and tried to jump up on the garbage truck. And was that a conclusion that a jury could possibly draw from the available evidence? I had trouble just understanding how mechanically, if he was standing on the ground, he could have ended up on the hood of the pickup. It just didn't make sense to me. So what you're telling me is there's now some additional information and some additional pictures that make that not a likely or even a plausible explanation for what happened. I'm not prepared to rule on that. It's just that I was surprised there were so many more pictures than what were actually presented. And it's possible that after I see those pictures and whatever additional information each of you supplied, that I could conceivably change my mind on that. That's why I asked for it to be reheard. It wasn't fair for me to rehear it based on new information without giving Mr. Millenbach the opportunity to address the new information. So I'm sure I'll see you back, gentlemen. I'm not going to hazard any more on this one today.
Okay.
Your Honor, Mr. Ryan and I talked a couple of weeks ago and about the possibility of facilitating this matter, maybe a settlement conference, however the court would be inclined. I'm not sure when the trial is going to be scheduled for. I understand sometime in September, possibly. That does give us a fair amount of time. Maybe, do you know when the trial would be held?
No, not with any certainty. I'm optimistic that in another month, we're going to have a really good idea of how quickly we're going to be able to resume normal operations. But as of today, I don't have anything definite. As of today, we're still on phase 2. So, unless something changed today and I haven't been informed of it yet, that's a distinct possibility too.
Happens to
So
you.
I would strongly encourage some conversations about resolution, and I'm willing to do a settlement conference. Although, since it's a jury trial, I don't think I'm foreclosed from doing that. But if you gentlemen would like to take an attempt at a settlement conference, I mean, we're still Zooming for something like that. And I wonder how effective a settlement conference is when you're Zooming, but I'm willing to give it a try.
Well, Your Honor, I will talk to my client about that. I'm not confident that EMC would be willing to put the kind of money up that it might take to get this case resolved. I don't want to waste your time or Mr. Millenbach's. So I'll talk to my client about that and then circle back with Paul.
If you would like a settlement conference, just let my law clerk know, John Fleming.
If I could ask one question, only because I'm going to get this question, relative to an ultimate ruling on the motion, the summary disposition motion about occupancy or occupying, are you going to issue a written opinion, or I just need to know what to tell my client?
I haven't seen whatever has been filed, so that stuff normally doesn't come up to me until it's scheduled for a hearing. I was of the impression that we would have another hearing on this once a response was filed by Mr. Millenbach.
I kind of thought that's what this was.
Yeah, I did too. I did file a response. I don't know. Did you get it, Mike? I don't know if the court. Okay.
Yeah, I did, and I think I filed a reply to your response. Kind of like a motion. So,
my understanding is that the only dispositive motion up today was with respect to the bankruptcy filing.
No.
That's why I was asking. I was wondering, well, where is that other stuff? I know I ordered an opportunity for a response. But I didn't see them, frankly. All I saw was stuff related to the bankruptcy filing. And maybe I just didn't look deep enough. I'm sorry. When I saw the bankruptcy stuff, I just assumed that's what was being renoticed for today, as well as the motion to substitute.
I think Mr. Ryan had captioned it as a motion for rehearing. And I filed a response. Certainly we can come back at a later date for that.
Oh yeah, I definitely remember reading the motion for rehearing. And that's when I read that, I said, because there's no hearing on a motion for reconsideration unless I order one. But at least what was in my mind when I said I want to see plaintiff's response to this motion for rehearing was that we would have another hearing. Now you're telling me you both were expecting that to be today.
Yeah.
Unfortunately, I didn't expect that, so I haven't read what you filed.
Okay.
So I think what I would like to do then is on that issue is have you come back at a time when I've had the opportunity, one, to refresh myself with the motion for reconsideration and documents that were filed with it, and then to review your response, Mr. Millenbach, so I can respond intelligently to your arguments. I'm going to guess that we could probably do that a week from today. No, that's Memorial Day. So maybe a week from Wednesday. Let me pull up my calendar and see, and we'll see what works for you guys. I normally will hear these on Monday and Wednesday afternoon. So let me look at what next Wednesday looks like. That's June 2nd. I've got another dispositive motion scheduled at 3. You could schedule it for 2:30.
That works for me. Is that good for you, Paul?
That works for me, yes.
You want me to renotice it, Judge?
Tasha, can you just put that on the docket for me?
Okay.
Since you're both aware of it, I'll just put it on there. 2:30 Wednesday, June 2nd, hearing on motion for reconsideration.
Okay.
Okay, very good.
And that way I will have read everything, and I think, and looked at whatever additional information has been submitted.
Okay, great.
All right.
All right.
Thank you.
Thanks, Judge.
Have a good day, gentlemen. We'll see you in a week.
Okay.
You can take us off. Those folks have oh no, they're still in the breakout room.
Let me take you off.
Yeah, they're still in the breakout room. So I'm assuming they're trying to work something out. So that Pratt case was a fatality where a guy driving a pickup truck slammed in the back of a garbage truck and killed one of the garbage operators. I think he claimed that there was, he was coming into the bright sun and just didn't see whatever. And he only had $20,000 policy limits. So the claim is for underinsurance coverage, which the garbage truck company carries in case there's an injury involving somebody at fault who's got low policy limits or no policy limits, no policy rather, driving without insurance. Anyway, it was in front of me quite a few weeks ago, and they had a handful of pictures, and there was evidence that the guy ended up on the pickup. So what was suggested, and I think was plausible, is he looked up at the last minute, saw this truck, and just tried to get out of the way. The reason the policy is challenged here is because if he wasn't on the truck, the coverage doesn't apply. It only covers if he was getting on, getting off, or on the vehicle at the time of the impact. If he was truly just standing on the ground, then you never get at the policy for the truck, the garbage truck. So there were very few pictures and nobody actually witnessed it. And apparently the driver of the pickup truck didn't see anything, just slammed into him. So he didn't know, he didn't have anything to offer. The guy on the other side of the pickup of the garbage truck didn't see the impact, and nobody else witnessed the impact. So, but he ended up apparently on the hood of the pickup truck. So I'm imagining, you know, you're standing on the ground. A pickup truck is, you know, if you're standing upright, the hood's going to be somewhere up in this area. How in the world did he get up on the hood? So I said, yeah, maybe the jury will conclude he jumped up onto the back of that truck to try to get out of the way. And it doesn't matter why he was on the truck. If he was on it when it happened, there would be protection. So anyway.
So does he have to be on the garbage truck when he gets it? Am I understanding that correctly?
On